Welcome to the second session of the symposium. My name is Donal O'Donnell. The second session is titled Liberation Through Law, Daniel O'Connell and the Path to Justice. And it is, I think, central to our understanding of Daniel O'Connell that he was a lawyer and a barrister. I think it's important to make that, to identify both those aspects of his life, because he wasn't simply, as Antonio Fraser described him, the greatest orator of his time, but he was also an extremely able and learned lawyer. And certainly, I think it is impossible to understand his public life without understanding and appreciating his achievements in his professional life as a barrister. We have a very distinguished panel of speakers and a limited time, and I hope you understand that as a Chief Justice and Judge, I have had a long career of failing to keep barristers to the time that they agreed to speak for. So what I hope to do is to leave the floor to them. At the moment, we propose to have 3 contributions and then a time for questions and answers, and then a further 2 contributions and questions and answers. But as the afternoon proceeds, we may run the contributions into one session and then have questions and answers. The first speaker today is Miss Justice Nessa Cahill, who's a judge of the High Court. She was educated in Trinity College Dublin, as well as the College of Europe in Bruges and the Honourable Society of King's Inns. She was called to the bar in 1999 and to the Inner Bar in 2020 and became a High Court judge last year. She practiced mainly in the field of commercial law, intellectual property, and she's the author of a book on company law enforcement. And even the most enthusiastic fan of Daniel O'Connell, I think, would struggle to find an intersection between Daniel O'Connell's legal career and the topic of company law enforcement. But Nessa is going to speak today about something she has her own experience of now from both sides of the courtroom, which is Daniel O'Connell's interaction with judges and judges' interactions with him.
I have to say I'm singularly pleased to be in here today. This is the first time I've been in this room since I was an undergraduate law student in Trinity. And it's an honour and somewhat unexpected for me to find myself addressing the topic of Daniel O'Connell. As the Chief Justice points out, my areas of legal endeavour didn't really heavily overlap with those of Daniel O'Connell, but I have been delighted to learn and I've decided to grasp the opportunity of trying to understand O'Connell's appreciation of judges, his interaction with judges and his experience of them. As a new judge, I very quickly learned that the sure way to bring a judge down a peg or two is to get them to study Daniel O'Connell. To say that he was not universally complimentary about the judiciary would be somewhat of an understatement. Patrick Egan, in his wonderful book, King Dan, quite accurately notes that in fact O'Connell was never complimentary about judges. To give just some examples, and these are typically included in a fee book he used to maintain, not a practice I encourage or hasten to add. His fee book included apparently accounts of his fees, but also his views of the then sitting judges. So just to give you a flavour of this, he described Chief Baron George Daly as extremely ignorant, knows nothing of the law, and has not the art to conceal any part of his want of knowledge. These qualities, added to a difficulty of enunciation, have brought him into contempt with the bar and the country. Judge Luke Fox, who was widely regarded as a good lawyer and an advocate, was said by O'Connell to be morose, sour and impetuous as a judge. He recorded of Baron Kilwarden as a judge that his pompous inanity is insufferable. Even Judge Robert Day, who was a friend and fellow Kerryman of O'Connell's, wasn't spared his sharp tongue. He said of him, "Most innocent of law was my poor friend Day." He was not alone in this view of Judge Day, unfortunately for the judge. John Philpott Curran famously said of Judge Day that his efforts to understand a point of law reminded him of nothing so much as the attempt to open an oyster with a rolling pin. I have to comment, it's probably just as well social media wasn't around in those days. It would have been quite a dangerous milieu for them. But for Daniel O'Connell, these were not just idle observations. His contempt for certain members of the judiciary was just as apparent in the courtroom itself. In one case, he happened to be in court when a junior colleague was being pressed to concede a particular point. Daniel O'Connell wasn't briefed in the matter, but understood that he was likely to be in the event that there was a new trial. He therefore intervened and encouraged his junior colleague not to make the concession sought. Baron McClelland, the presiding judge, admonished him sharply, stating that when I was at the bar, it was not my habit to anticipate briefs. O'Connell's swift retort was, when you were at the bar, I never chose you as my model, and now that you are on the bench, I shall not submit to your dictation. In another case, he sought the admission of certain evidence. The judge decided to reflect on it overnight, not unreasonably, I would have thought, before ruling in O'Connell's favour in the following day. Most barristers would be pleased with that victory and would let the matter lie, but not O'Connell. He retorted, "Good God, my lord, if your lordship had known as much law yesterday morning as you do this, what an idle sacrifice of time and trouble you would have saved me, and injury and injustice to my client." Not recommended words in a courtroom nowadays, I would suggest. He was also willing at times to bend the rules. There was a practice at the time he was practicing of junior counsel and senior counsel alternating the witnesses they took in a trial. In one case, he had a senior counsel, but one who was not as well equipped as O'Connell, presumably in O'Connell's own mind, to take the key witness. O'Connell therefore orchestrated a situation where a random person who happened to be in the courtroom was called to give evidence. It became apparent after a couple of moments he had nothing of use to say. He was discharged, and O'Connell then took up his turn examining the key witness in the case. He was known for using various theatrics and reported to, on occasion, throw down his bag on the bench, fling his brief at his solicitor, and storm out of court in faux outrage at some perceived injustice to his client, before ostensibly cooling down, returning to resume the case, to great effect on the jury. He'd mutter some token apology to the bench, but would resume the case. He carried this to extremes in one case when he was acting in a murder trial before Thomas Lefroy, who was Jane Austen's one-time love interest. Lefroy was then sitting as the judge for the first time, having been asked to step in for a judge who'd fallen ill at the last minute. The evidence in the case happened to weigh very heavily against O'Connell's client, so he put a number of plainly, blatantly impermissible questions to one of the chief witnesses. These objections were invariably, of course, made by the prosecution, and these were correctly upheld by Lefroy, at which O'Connell exploded, saying, "Are you refusing me permission to defend my client, my lord? I leave his fate in your hands, and his blood will be on your head if he be so condemned." He left the court and paced outside for the remainder of the trial. He later explained, "My only chance was to throw the responsibility on the judge, who I knew would in the circumstance shrink from being in any way instrumental in causing a capital conviction, especially as it was his first appearance on the bench." Lefroy didn't disappoint. The result was an acquittal, but I have to confess, as an inexperienced judge myself, I do have some sympathy for an inexperienced judge facing Daniel O'Connell at full tilt. But O'Connell's stinging verbal rebukes and unorthodox tactics in court cannot be appraised in a vacuum or through today's lens. The context has to be understood, and it was that many judges appointed post-1800 were elevated owing to political double-dealing in support of the Union, and in O'Connell's view, these individuals entirely lacked the skills required. Ongoing discrimination against Catholics was rife, and one obvious point was that Catholics were not then eligible for elevation to the inner bar or to the bench. Seán O'Faolain records that it was one of the basest periods of the Irish bar from the point of view of corruption. Capital punishment was also widespread, including for property offences. O'Connell described in vivid terms defending three brothers, the Cremin brothers, who were convicted of murder on evidence that he regarded to be flimsy. His clear view was that these were three innocent men. He described watching their mother clutching each of them as they went to the gallows, all of 22, 20 and 18 years old. So one can perhaps understand why the rules were bent in some cases. And his antipathy towards certain judges can be well understood and shared, indeed, when you look closely at their character and some of the judges he encountered. One striking example is Lord Norbury. He was Chief Justice of Common Pleas from 1800 to 1827, known as the hanging judge, and famously the judge who sentenced Robert Emmet to death, having apparently harassed him during his closing speech in the court. O'Connell did not mince his words regarding Lord Norbury. He called him the Thing, saying he was a pretty gentleman at the bar, which I don't think he meant as a compliment. He went on to say that on the bench he is ridiculous. The Thing is fond of blood, he said. He also said of Lord Norbury, he did not understand, nor was he capable of understanding, a single principle of law. Norbury's court is recorded in various different accounts of the time as being like a circus. Norbury himself enjoyed engaging in puns and jokes, and crowds would flock to the public gallery to witness this entertainment. Given that this was often in cases involving death penalties, it doesn't take much to understand the distaste that's appropriate for that kind of conduct. O'Connell was heavily critical of this failure to show respect and to respect the gravity of the bench, remarking that the seemly gravity of the bench was in the hand of a bad keeper when committed to the care of Lord Norbury. There are also several examples of Norbury convicting and sentencing to death people who were widely known to be innocent. After one such case, O'Connell questioned in open court whether Norbury's conduct was a fit subject for parliamentary inquiry. This wasn't the only time that O'Connell raised the question of parliamentary inquiry as regards Lord Norbury. There was another affair in 1822. In that case, what happened was that a letter had been sent by the then Attorney General, William Seán, to Lord Norbury, suggesting that he engage in some form of use of his judicial office for political corruption purposes. The letter was discovered when an overstuffed chair of Lord Norbury's was sent for reupholstering, and the letter was found. O'Connell regarded the letter as evidence of a conspiracy between Seán and Norbury to pervert the judicial office into a political engine of calumny and bigotry. He was heavily critical of the failure of William Plunkett, who had since replaced Seán as Attorney General, to take any action. The matter was raised in Parliament, but to no end. Robert Peel intervened as Seán's friend to deflect the attention and instead, remarkably, criticised the individual who found the letter and brought it to public attention. A few years later, not deterred, Daniel O'Connell himself prepared a petition to be presented to Parliament for the removal of Lord Norbury. This was said to be on the basis that Norbury was then 85 years of age, deaf, incapacitated by old age, and, he said, so subject to lethargic stupor that he would frequently fall asleep, fast asleep, in the middle of a trial. And he gave various examples of murder trials in which Lord Norbury, as the presiding judge, had slept through the entirety of the evidence. O'Connell carefully said in the petition that he did not base it on any imputation on Norbury's integrity or honesty or honour, but on the fact that he was utterly incompetent to preside over the fate of any human being, even on the most trivial charge. It was said to deeply affect the administration of justice in Ireland. The petition was presented by a newly elected Whig MP, Mr James Scarlett, to the Parliament, Houses of Commons, on the 5th of May 1826, and was opposed by the then Chief Secretary for Ireland, Mr Henry Colburn, who I think interestingly did accept that the idea of a retirement age may be a reasonable one, but that it would be unfair to impose it on Lord Norbury alone. Robert Peel, who was then Home Secretary, professed himself proud to call Norbury a friend and suggested that Norbury had been induced to retain his seat just long enough to allow the petition to be presented. The suggestion was made that now that he knew his integrity wasn't being impugned by the petition, he'd be safe to resign without the shadow of an imputation. Norbury, of course, didn't resign without the shadow of an imputation or otherwise. The following year, there was a change in government, or change in Prime Minister. Scarlett became Attorney General, Peel and Goulburn lost their positions, and Norbury did finally then step down, but not before extracting the promise of an earldom. O'Connell was outraged at Lord Norbury being bought off the bench, and he bemoaned the state of Ireland, which has had its Chief Justice of the Common Pleas in the hands of a sanguinary buffoon for more than 20 years. His integrity was intact, then, needless to say. 3 years later, a sign of O'Connell's real pragmatism, I think, can be seen in a parliamentary debate about judicial salaries, where he made the following contribution. O'Connell's view in that debate was that it's extremely desirable that the retiring salary of judges should more closely approach the full allowance, in order that there might be less apology for judges retaining their offices after they've become unable to fill them with effect. I think you often hear talk of the pragmatism of O'Connell. I think that possibly is an illustration of it. And yet, despite O'Connell's outspoken challenges to and virulent criticisms of individual judges, he was unparalleled in his success, as he was wont to boast, most uncharacteristically for a Kerryman. He also seems to have been treated with thorough and deserved respect, and maybe a smidgen of fear, I think, by the bench, even those he most despised. And despite his flourishes and what was termed his verbal violence, he got away with a lot. There's a famous tale of a trial in which O'Connell was interrupted repeatedly by an opposing barrister's deliberate attempts to provoke him. O'Connell apparently resisted repeatedly and held his cool until finally there was an intervention when he was putting an important question to a key witness. And when this intervention came, O'Connell erupted, shouted in tones that reverberated across the courtroom, "Sit down, you audacious, snarling, pugnacious ramcat." Apparently, even the judge was rolling in his seat with laughter. The story goes the barrister was from then on known as Ramcat. For my part, reading accounts of his conduct in court of this nature, I'm a little bit torn. On the one hand, when I conduct a case in court, I consider truthfulness, respect, dignity, courtesy to be absolutely crucial to the fair conduct of legal proceedings. But on the other hand, part of me would really love to see O'Connell in full flight when he was in court in the day. But one point that does firmly emerge from the many anecdotes you read about him is that he did have a strategy at times of subverting from within, and his dismissiveness of many on the bench was pronounced. But I don't believe that in any way this undermined his deep-seated belief in the system of administration of justice and his strong desire to strengthen and improve appointments to the Irish bench to enhance that system and public confidence in it. Indeed, this continued even after he ceased practising at the bar. His determination in this respect can be particularly seen, I think, in a series of letters he exchanged with Lord Duncannon, who was then Home Secretary in 1834. There was a vacancy created by the death of a Judge Jebb at the time. O'Connell took it upon himself to start correspondence regarding who he thought the appropriate replacement for the judge ought to be. He said that the then newly formed Whig government under Lord Melbourne needed to prove itself at this time. He referred to one particular individual who appeared to be next in the pecking order for judicial appointment, a Mr. Philip Crampton. And O'Connell said it would be a disgrace, an irretrievable disgrace to the ministry to put on the bench so incompetent a man. He continued in similarly gentle tones to say he has no character for high-mindedness or public integrity. His conduct at the bar is sneered at, his legal knowledge is by no means adequate, and if you inquire from dispassionate persons as to his conduct at the last Munster Circuit, you will find an almost total want of judicial qualities. In short, it is my painful duty to warn you of the utter discredit you will fall into if you make Crampton a judge. One sop that was given by O'Connell was that a mastership in Chancery might be procured for him, and he would there be less liable to do injury, and hence have only such points put before him as could be elucidated for him by any skillful accountant. I do need to pause there. I've been sitting in the Chancery Division of the High Court since my appointment, and I feel duty-bound to point out that the significance and complexity of Chancery work has evolved significantly in the last 200 years. But moving on to O'Connell, he put forward in his letters to Duncannon 6 different names of Liberal barristers he believed were suitable for appointment, 1 Presbyterian, 2 Catholics and 3 Protestants. From my research, it seems that at least 5 of these were subsequently appointed to different judicial offices. His belief in merit and egalitarianism without emphasis on connections or politics can be seen in his advice to Lord Duncannon. His view is that the judicial vacancy should be filled by an able lawyer, no matter what his politics may be, whether Catholic or Protestant, who never shrank from the tranquil but firm avowal of liberal and just opinions. He had also previously opined that what it takes to be a good judge is to be a good practical lawyer. In this area, as many others, O'Connell stood out and was ahead of his time. What is also interesting to note is his recognition when writing to Lord Duncannon that my suggestions will, as perhaps after all they ought to be, totally disregarded. That may indicate, you would think, an awareness on his part that the judicial process should be free of interference, but that didn't, of course, stop him. He went on to caution Lord Duncannon that the fate of your administration in Ireland depends mainly on the appointment you make. He said it is time for you to take one step to conciliate the people of Ireland, to begin to give the people some reason to confide in the administration of justice, whilst you commence to cleanse the sources through which it may flow. This recognition of the need to give the people of Ireland confidence in the administration of justice, to restore their faith in the judicial order, shows remarkable vision. His advice was not, however, taken. Crampton was appointed to the King's Bench in October 1834. O'Connell wrote, "I do not know when I felt more of political disgust than I did with the present ministry." In a letter to Lord Duncannon, he talked of feelings of pain and sorrow upon learning of the appointment, saying, "I almost weep while I write." He concluded that letter with the following stark warning: "You are a much greater repealer than I am. Your conduct and that of your colleagues has made the people more inveterate for repeal than any arguments or exertions of mine could possibly do." This demonstrates, I think, how vital O'Connell regarded the appointments to the bench to be. For him, the failure by those in power to make fair and deserving appointments, to seek to build confidence, undermined the entire system of government and any promise of change, and strengthened the repeal movement. But despite these acute disappointments, he did not lose faith in the system of administration of justice. This, I think, can be seen in his reluctance to refuse the offer of judicial appointment when it came his way in 1838. He referred to his heart being sad and heavy with the sacrifice, but said, according to William O'Neill Daunt, "Ireland could not spare me now." So he never did become a judge. But it seems that his battles with unfit and politically partisan holders of judicial office throughout his legal career strengthened his determination to protect and enhance the judicial function, and fuelled his belief in the importance of ensuring that those entrusted with administering justice are competent, fair and independent, as a crucial step in the protection of individual rights and a just society. And while the lively tales of his life at the bar may not quite resonate with the courtrooms of today, this commitment to a strong and independent judiciary, whatever the political regime in place, is as universally relevant now as it was then. Thank you.
Thank you very much, Nessa. The next speaker is Seán Guerin, who's the chair of the Council of the Bar of Ireland, who are co-sponsors, I think, of this event. He was educated in UCD, the University of Nancy, the Honourable Society of King's Inns, was called to the bar in 1997 and to the Inner Bar in 2013. And he's been closely involved in a number of events to commemorate the 250th anniversary of the birth of O'Connell. The bar have an annual Daniel O'Connell lecture, and last week awarded the first Liberator scholarship, which was presented by former President Mary McAleese, and is a great indication of the continuing significance the bar attaches to its connection with Daniel O'Connell. Seán O'Fuilon famously said that Daniel O'Connell hardened his idealism in the filthiest cockpit known to man, the Irish bar, before or after the Union. That makes Seán Guerin the ringmaster of that particular cockpit. And to give you the latest account from there, I'll call on Seán now. Thanks.
Thank you, Chief Justice. I should say that this is also the first time I have been in this theatre since I was a law student. Although I was a law student in a different, and to spare blushes in present company, I won't say a better university. It's a little bit further out the N11. And all I will say is that if anyone were inclined to infer from the fact that my contemporary Nessa Cahill has already been elevated to the bench while I remain a humble jobbing barrister, I will remind you that every other member of the panel went to the other university, including the Chief Justice, as did our gracious host, Professor Geoghegan, and on that evidence I will rest my case. On this very day, 212 years ago, the Dublin Journal published its account of the trial at the Court of King's Bench of the King and John Magee, the publisher and printer of a rival paper, the Dublin Evening Post. Daniel O'Connell led the defence of John Magee. Although unsuccessful, his defence, and in particular his closing speech, made a sensation. And it is that speech upon which I propose to turn your attention today. The report of Robert Peel, the Chief Secretary to Lord Whitworth, the Lord Lieutenant, on the speech said, O'Connell spoke for 4 hours, taking the opportunity of uttering a libel even more atrocious than that he was proposing to defend, on the government and on the administration of justice in Ireland. He insulted the jury collectively and individually, accused the Chief Justice of corruption and prejudice against his client, and avowed himself a traitor, if not to Ireland, to the British Empire. A good day's work all told, you'll agree. Among his 19th century biographers, the speech was extremely highly regarded, and Luby said, in the entire range of forensic oratory, if we accept the speech of Demosthenes on the Crown, the masterpiece of human eloquence, there is no oration which surpasses or even equals in truth, in scorn, in defiance, boldness, vehemence and power, O'Connell's wonderful defence of Magee. This high regard has not entirely survived, and the speech has been criticised by more recent commentators on the grounds that his language was unbecoming, that the speech was not calculated for forensic effect but for political force, and even that the speech sacrificed his client's legal interests to O'Connell's political ambitions. My purpose today is to reconsider those criticisms of O'Connell's defence of Magee. The libel alleged and ultimately proved against Magee arose from his publication in the Dublin Evening Post on the 5th January 1813 of a critical review of the departing Lord Lieutenant, the Duke of Richmond. It was also critical of the worst of his predecessors, who were identified as, quote, the profligate, unprincipled Westmoreland, the cold-hearted and cruel Camden, the artful and treacherous Cornwallis, close quote. Although much had changed since their times, the review noted, the system and principle of government in Ireland remained unaltered. A principle of exclusion, which debars the majority of the people from the enjoyment of those privileges that are possessed by the minority, and which must therefore maintain itself by all those measures necessary for a government founded on injustice. The article thus engaged not merely the reputation of Richmond and the competence or effectiveness of his regime, it constituted a direct challenge to the government of Ireland by Britain and the exclusion from that government of the majority Catholic population. The King and John Magee was unavoidably a political case, and it demanded a political speech. William Sorin, the Attorney General at the time, whom Ms. Justice Cahill mentioned, in his address to the jury, spoke of the danger in allowing, as he put it, every ruffian to slander and revile and deal out his Billingsgate. And ruffian was the description he repeatedly applied to Magee, although he did not refrain either from stooping to compare him to the keeper of a house of ill fame. He argued that any attempt to defend the content of the publication would be to furnish matter for new libels against the government. The criticism of Richmond, he said, could only have come from a faction so desperate and a ruffian so atrocious who could compose and deliberately publish so malignant a calumny. He said that the Dublin Evening Post was more inflammatory, seditious and atrocious than anything published in the press leading up to the rebellion of 1798, which itself was due in a great degree, he said, to the licentiousness of the press. The offence of criminal and specifically seditious libel is fully explained by the Law Reform Commission's observation that any person who questioned the legality or policy of government committed the offence of sedition. Thomas Erskine, in his defence of John Stockdale in December 1798, had said, "Truth is undoubtedly no warrant for writing what is reproachful of any private man. But as to writings on general subjects which are charged as of a seditious tendency, it is far otherwise. The people of England," he said, "are not to be kept in the dark touching the proceedings of their own representatives." But of course, keeping the people of Ireland in the dark was entirely the purpose of the prosecution. O'Connell's own view of the law of libel was pithily expressed in a letter of June 1833 to Richard Barrett, who had been convicted of libel for publishing one of O'Connell's own letters in the Pilot. "Every letter I ever published," he said, "could be declared a libel. I described the libel law as that which could produce a conviction with a proper judge and jury for the Lord's Prayer with due legal innuendos, as they are called. And if the law was inhospitable to the defence of Magee, the jury was unlikely to be any less so." Speaking of the Attorney General, O'Connell said to the jury, "Gentlemen, he thinks he knows his men. He knows you. Many of you signed the No Popery petition. He heard one of you boast of it. He knows you would not have been summoned on this jury if you had entertained liberal sentiments. It is too plain that you are not selected for this jury from any notions of your impartiality." He was nothing less than frank in his criticism of the entire jury selection process and of its consequences for his client. He said, "Here it is that I could wish to address a dispassionate and an enlightened jury. You are not, you know you are not, of the selection of my client. Had he the poor privilege of the sheep stealer, there are at least 10 of you who would never have been on his jury." It's not the purpose of this paper to set out in any detail the content of O'Connell's speech. In Magee's case, it is too long, too compelling and too enjoyable to benefit from compression into the time available today, and besides it is well summarised elsewhere, not least in Patrick Geoghegan's biography. Allow me just to trace a few key features of his speech that seem apposite for present purposes. His confidence in the larger political cause he expressed in this way: "This system cannot last. He may insult, he may calumniate, he may prosecute, but the Catholic cause is on its majestic march. Its progress is rapid and obvious, and its success is just as certain as the return of tomorrow's sun. We must be soon emancipated. Our emancipation is certain and not distant." In the speech, he considers in length and in detail the content and the context of the publication, including a discussion both of the law of libel and the blessings of a free press. He offers what he candidly admitted was his opinion rather than a statement of the law, that in the discussion of public subjects and of the administration of public men, truth is a duty and not a crime, reflecting accurately Erskine's views but not Irish law. He then proceeded to explain and justify every word of the publication, relying on Leland's History of Ireland to support the charges laid against Richmond's predecessors, including murder, the packing of juries, and corruption of the judiciary, so that he could say to the jury, "The language of the publication before us is mildness itself, compared with that which the truth of history requires, compared with that which history itself has already used." At one point, O'Connell was presented with what any barrister loves, that is, an opportunity to advance his case using the published writings or speeches of opposing counsel. Seán had accused Magee of Jacobinism, and O'Connell was able to invoke Soran's own defence against the same charge which had been made against him for the anti-union views he had expressed in 1800. "May I be permitted just to observe," said O'Connell, "how much more violent this agitator of the year 1800 was than we poor and timid agitators of the year 1813. When did we talk of resistance being a question of prudence? Shame upon the men who call us intemperate and yet remember their own violence." There is no doubt, however, that he went on in the concluding parts of his speech to voice the most stinging personal criticisms of the Attorney General. His peroration left no doubt of his views of the jury, were they inclined to return the verdict he sought, or indeed the contrary. "If amongst you," he said, "there be cherished one ray of pure religion, if amongst you there glow a single spark of liberty, if I have alarmed religion or aroused the spirit of freedom in one breast amongst you, Mr. Magee is safe and his country is served. But if there be none, if you be slaves and hypocrites, he will await your verdict and despise it." The jury convicted. The matter was before the court again for sentence on the 27th of November, the trial itself having taken place on the 26th and 27th of July. And on that latter occasion, a most notorious row erupted between Seán and O'Connell when the Attorney General urged the court to treat Magee's publication in the interim of the record of the trial, and in particular of O'Connell's speech, as a matter aggravating the sentence. In response, O'Connell said in plain terms that had Seán made the remarks he made in support of that application outside court, they would have merited chastisement, physical punishment. Questioned by the court and told to take care what you say, sir, he repeated that view. And in the end, it was the Attorney General, on the prompting of Mr. Justice Day, as Ms. Justice Cahill said, O'Connell's Kerry friend, who backed down. O'Connell said that he rejoiced in Seán's public disavowal of what had been said, but went on to make an impassioned speech for the importance of the independent bar, saying, "It is the first interest of the public that the bar shall be left free. In short, the public are deeply interested in our independence. Their properties, their lives, their honours are entrusted to us. And if we, in whom such a guardianship is confided, be degraded, how can we afford protection to others?" And he concluded with a barely concealed and vicious personal attack on Seán. The intemperance of his language in response to Seán and the ire he aroused in court caused Magee to instruct another of his counsel to disown O'Connell's conduct and speech. But these events, it must be understood, happened 4 months after the speech for the defence at trial, and do not therefore constitute in themselves grounds for believing, I should say, that Magee was in any way disappointed by O'Connell's defence of him, or that O'Connell had sought to take unauthorised personal political advantage of the brief he held. There is indeed reason to think otherwise. The fact alone of Magee's having published the record of the trial seems on its face to suggest that he endorsed the conduct of his defence, and the content of the preface to the published trial supports this interpretation. It says, he, O'Connell, just defended Mr. Magee as Mr. Magee wished to be defended. No flattering, no parley with the Crown lawyers, the jury or the court. With regard to the mode in which Mr. Magee has been defended, he has only to reiterate the assurance he has so repeatedly expressed in his paper, that the line of defence taken for him, that the topics upon which Mr. O'Connell has insisted are precisely those he was instructed to adopt. And indeed, into 1814, O'Connell continued to act for Magee in other similar prosecutions. It's not my purpose today to argue that O'Connell's speech in defence of Magee is the greatest bar one since Athens fell under the control of Philip of Macedonia, nor even to insist that the hagiographers of the 19th century should be preferred to the historians and biographers of this one or the last. But I do sense that increasing distance in time and in affairs from O'Connell has allowed an unjustified degree of criticism and disapproval to develop, and that such criticism and disapproval fail to fully appreciate the enormous difficulty of his task as a barrister. It was O'Faolain who most memorably criticised O'Connell's language, writing, "How different it all is from, let us say, Robert Emmet with his plumed hat and his naked sword. Everybody indeed who regards gracious living, nobility in thought and word and behaviour, must read this demagogue with a curl of distaste. O'Connell did a great deal to kill gentle manners in Ireland, to vulgarise and cheapen us." This is a troubling and indeed a somewhat mysterious passage. It was, after all, O'Faolain himself who said that O'Connell, quote, took the beggars of Limerick and gave them a kingdom of the mind, close quote. So that both as concerns the condition of the Irish people as O'Connell found them and his effect upon them, the passage quoted above seems unfair. If, in the person of Emmet, or the pathos of his final speech, the ascendancy regime of Ireland could lay any claim to gentility or refinement, it could not avoid admitting ownership also of the cruelty and buffoonery of John Toler, Lord Norbury, who presided over the trial, nor of the corruption and venality which placed him there. Indeed, it seems unfair to blame O'Connell for our inability to all speak with the refinement of Robert Emmet. It's a little bit like blaming the GAA for the fact that we don't all play soccer with the skill of Cristiano Ronaldo. O'Connell's language and even his manner in court could certainly be provocative and personally damaging, and it was clearly intended to be so in the case of Seán. But in what circumstances? He was at trial before a packed and biased jury, in a lost cause, legally speaking, selectively prosecuted for the purpose of suppressing dissent by an Attorney General who pandered to the prejudices of the jury, traduced his client, and condemned O'Connell's political associations for the purpose of confirming their bias. The sheer force of his response is galvanising, and his willingness to expose to the light of the harshest criticism every feature of so corrupt and oppressive a system is a model of forensic bravery. The suggestion that the speech was rather a political than a legal one bears not a moment's examination. The prosecution was wholly political in intent and in content. O'Connell saw that and seized the opportunity presented by so manifestly political an occasion to advance the politics that he and Magee shared. That was not a failure of legal skill. On the contrary, it was a triumph of forensic advocacy under oppression. Demosthenes could appeal to the shared oaths of the Athenian jury, and Cicero could cry civis Romanus sum, as Erskine could insist that the people of England would not be kept in the dark. But O'Connell, unlike those forensic greats, was an outsider in the system in which he practised. His achievement in Magee was threefold. First, he turned the forms and processes of an unjust and oppressive system against itself, using a political prosecution against dissenting speech as the means to condemn the oppressor and amplify the dissent. Secondly, he seized the opportunity presented by Seán's ill-advised attack on his politics to go beyond the scope of the historical criticism of which the dissenting speech consisted, he went as far as to make a powerful case for the fundamental justice of the wider cause. His bold claim, "Our emancipation is certain and not distant," is electrifying even now written on the page. What must it have sounded like in his voice, in that court, in that trial, in those times? His challenge to the jury must be seen in that light, not as an ill-considered failure to appeal to his audience, but as an unyielding insistence in the face of stubborn intransigence that he had right on his side to all who were willing to see it. Thirdly, his insistence not just on the forms of the law, but on public adherence to the law itself, was more than a necessary protection against anticipated injustice. It was a powerful expression of the superior moral right his cause could and would lay claim to. He certainly did not put his own position or interests before those of his client. That underestimates significantly the danger in which he placed himself personally by the approach he adopted. Magee was happy to publish the speech and indeed the trial, and appears in the latter case to have done so in terms that expressly confirmed that the speech was consistent with his instructions. O'Connell's intervention at the sentencing hearing, although it prompted a withdrawal of instructions on the day, must also be seen in context. He, in my view rightly, saw Soran's conduct not just an attack on him personally, which it undoubtedly was, but also as an attack on the independence of the bar, particularly in political cases. O'Connell fully understood and articulated the importance of an independent bar for the defence of individual rights, especially in a system of government founded, as the article Magee published had said, on the principle of exclusion. When his uncle and patron, Huntingcap, wrote to him in mid-December 1813 to complain of his conduct and to insist that you will in future conduct yourself with calmness, temperance and moderation towards Soran, O'Connell replied, "I pledge myself to you not to begin. I pledge myself to you not to travel out of the strictest line of moderation in tone, manner and language, unless I am first attacked, and it is in this sense that I understand your direction." So when Maro Itoje told the referee on Saturday morning that the reason the Lions players were getting involved in a fight was because the Australians had started it, it was not just because he was leading a mostly Irish team, he was channeling the spirit of O'Connell himself. In the final analysis, the criticisms of O'Connell's conduct and speech at the various stages of the Magee trial failed to appreciate that O'Connell was in a fight which he didn't start and in which he laboured under enormous and fundamentally unfair disadvantages. His refusal to bow his head, his insistence not just on the justice of his and his client's cause, but on using the process of the law to proclaim the justice of that cause and to denounce, in trenchant and unapologetic terms, the injustices of the system of law and government under which he operated, were simply magnificent. And if his denunciation extended to personal criticism of those who had risen to prominence and position by what he called that canting, peculating loyalty which seeks to enrich itself by cringing submission to the powerful and insulting oppression to the weak and humble, what of it? It was a valid, if not an effective, correction. He was a model of forensic advocacy under an oppressive regime, observing at least the forms of justice. No one who has ever discharged the responsibility of the advocate could fail to appreciate the skill and the enormous bravery his performance required. O'Connell's conduct of the defence of John Magee remains an inspiration and an example to barristers and advocates the world over. Thank you.
Thank you very much, Seán. The next speaker is John Berry, Senior Counsel, and he, as has been indicated, was educated at UCD, but qualified as an engineer and then, I think, practiced as a management consultant. But finding those adrenaline-fueled professions altogether too volatile, unpredictable and precarious, he went to the King's Inns and was called to the Irish Bar in 2007 and took silk, became a senior counsel in 2024, where he has practiced in the sedate and less stressful world of full-time criminal practice, I think, John. And he's going to speak to us this afternoon on the distinction between O'Connell's private or pugnacity in his private life and his political pacifism. John.
Chief Justice, ladies and gentlemen, in the summer of 1869, O'Connell had been dead for 22 years. Jules Verne started publishing in serialized form his story, 20,000 Leagues Under the Sea, which introduced us to the mysterious Captain Nemo and his submarine, the Nautilus. The protagonist of the tale, Professor Aronnax, is attacked, then rescued, and then imprisoned by Nemo. While planning his escape, he finds himself alone in Nemo's stateroom, and he sees. Just then, my eye was caught by some etchings hanging on the wall, which I hadn't noticed during my first visit. They were portraits of great men in history who had spent their lives in perpetual devotion to a great human ideal. He describes 7 pictures. Thaddeus Kosciuszko, who fought for the Poles against the Russians and also in the American Revolutionary War, where George Washington was his general. Marcus Botzaris, a new Spartan, a hero of the Greek War of Independence, who died leading 400 men against 5,000. Daniel Manin, the leader of Venice, who fought the Austrians in the uprising. John Brown, an abolitionist who firmly believed that violence was the way to eradicate slavery and was executed by the state of Virginia following his failed raid on a federal armory in Harper's Ferry, an act which was described as a dress rehearsal for the Civil War. The Civil War, of course, where Abraham Lincoln, the penultimate man pictured, committed the Union forces to an industrial conflict. What then of the 7th man? Verne describes him in 4 words. Daniel O'Connell, Ireland's defender. At first blush, O'Connell's position on this wall perhaps seems odd. He didn't prosecute a war. He didn't die gloriously on a battlefield. He wasn't executed or assassinated by his adversaries. He wasn't sent into exile. Instead, on the contrary, he constantly told his followers to be peaceful. He urged restraint. In 1824, in proposing an address to be made to the nation in the Catholic Association, he advised his countrymen to refrain totally from all secret societies, from all private combinations, from every species of whiteboyism and ribbonism. And his reasons for doing that were clear, that ribbonism and whiteboyism and violence and outrage and crime have always increased the quantity of misery and oppression in Ireland and have never produced any relief or mitigation of the suffering of the people. This wasn't a new comment for O'Connell. After the failure of the 1798 rebellion, he said, in order to succeed for Ireland, it was strictly necessary to work within the limits of the law and the Constitution. And he echoed that again in 1828 while campaigning to be an MP for Clare, where he said that ours is a moral and not a physical force. But you can't take these comments and extrapolate from them that O'Connell was some type of pacifist or that he didn't have a temper. For to do so would be to completely miss the mark of the man, as both Nessa and Seán have shown. He was no pacifist. He joined the lawyers' artillery after being called to the bar. He was a man who found it very easy to take an insult, and a man who appears to be, given his acknowledged mastery of courts and the law, an even greater master of invective and cruel wit. He knew that his language was intemperate and violent. He deliberately made it so. After winning emancipation, he recollected how he was advised that he would never achieve anything if you remained so intemperate in his discourse. And his response? What did I do? Why, I became more violent, and I succeeded. And it's this tension within O'Connell, the restraint in respect of his adoption of force for achieving political gain and political goals, which he didn't do, when contrasted with the violence that's personal to him, that's fascinating. And that appetite for violence had fatal consequences in 1815 when he fought a duel with John de Stair. Now, O'Connell was born in a violent time in 1775. At that stage, the practice of duelling was reaching its zenith in Ireland. Killing remained a crime, but elite members of society were permitted to resolve affairs of honour outside the law. Society and the courts had become incredibly indulgent of how the protagonists of duels were to be treated. Rarely were the parties to a duel prosecuted, and if they were, the invariable verdict that was returned was manslaughter in self-defence, tantamount to an acquittal. Now, I'm going to suggest that one of the first signs that a particular aspect of a society's behaviour is a growing concern and causing a problem is when those who have the concern and are posing the problem adopt a voluntary code of behaviour for themselves. And the penetration of duelling in Irish society can be evidenced by the fact that at the Clonmel Summer Assizes in 1777, for the government of duellists by the gentlemen of Tipperary, Galway, Mayo, Sligo and Roscommon, and prescribed for general adoption throughout Ireland, a duelling code was established. This code reflected the growing unease with the growth of duelling in Ireland. It sought, by introducing rules, to restrain some of the more oppressive and rougher practices associated with duelling in the early 1700s. It also sought, by introducing more formality into duelling, to try and stem the growth of duelling in Irish society. One of the rules in particular is certainly, if not of universal, definitely of Irish application. Rule 14 of the duelling code provided challenges are never to be delivered at night, for it's desirable to avoid all hot-headed proceedings. And I can tell you, having reviewed much CCTV in the course of a criminal practice from Dublin's night spots, that hasn't changed. In the early 19th century, the law was starting to intrude into affairs of honour. And in particular, it sought to protect those who had been challenged but didn't want to answer the challenge. One of the mechanisms for doing that was that the challenged person would inform a magistrate who would then arrange for the arrest of the challenger, who would be placed under a bond, would have to enter into a recognizance, which would prohibit them from fighting the duel. If notified of an impending duel, the authorities could arrest both of the parties and seek to bind them by their recognizances. Recognizances, though, were only one element. There was also judicial sentencing and judicial deterrence. Judge Day, whom we've heard of, imposed fines on those who issued challenges for duels. And in 1808, a jury, having heard of a duel fought by William Hammond, returned a verdict of manslaughter, but in self-defence. Judge Mayne refused to accept that and directed the jury to return a verdict of homicide. This is why we have juries. They refused. And Judge Mayne was left with the verdict. But rather than discharge Hammond, he sentenced him to 12 months imprisonment and ordered that his hand be burnt. That sentence was appealed, but it was never overturned. The same judge sentenced a Major Campbell to death after he killed a brother officer in a duel. But that challenge was issued at night and there were no witnesses. Despite pleas for clemency, that sentence was carried out. These measures, recognizances and increased sentences, had an effect. James Kelly, who sampled the reporting of duels during this period, records a 50% decrease in the amount of duels that were fought between the period 1770 to 1780 and the first decade of the 1800s. Now, O'Connell was born into this and grew up in this and wasn't immune to the passions which provoked duelling and challenges. But it has to be said that the preventative measures which had been introduced to stem it or to stop it perhaps prolonged his life. When studying law in London in 1794, O'Connell challenged Douglas Thompson. When his second, George Bennett, went to present the challenge, Bennett was arrested, and both O'Connell and Bennett ended up bound to the peace. In 1796, O'Connell felt he had been insulted by his cousin, John Sigerson, in a letter and asked an acquaintance for the loan of pistols. That request was refused. But in 1800, O'Connell was prosecuting the same Sigerson in an assault trial where Sigerson insulted him in court. O'Connell reached out and hit Sigerson with his cane, which prompted an immediate challenge from Sigerson. Sigerson clearly thought better of it and hit upon a novel excuse not to fight the duel. He said that O'Connell leased lands from him and he couldn't afford to lose the rent. During the McGee trial, as you've heard, he threatened to chastise the Attorney General. Chastise means horsewhip. And then in August 13, again in court, he found himself following a clash with a fellow barrister, Maurice McGrath of Cork, engaged to fight a duel. When the parties went to the ground, but before they took their ground, a compromise was reached. But that compromise, which meant no shots were exchanged, led to speculation that perhaps O'Connell lacked courage. Now, accusing a leader of lacking courage is a serious thing. And financiers who coined the phrase "Trump always chickens out" very recently might have been surprised to see the United States Air Force bomb nuclear sites in Iran a few weeks later. I'm not saying that the two things are related. They probably aren't. But similarly, this talk of lack of courage may have prompted O'Connell's behaviour in how he accepted and fought the duel with de Stair in 1815. He made a speech in which he described Dublin Corporation as being beggarly. De Stair, a former Royal Marine officer who was a member of Dublin Corporation, took offence and issued a challenge. De Stair was reputed to be a crack shot, but at the time was near bankruptcy, and perhaps he thought by fighting O'Connell he would be able to improve his station or lot in life. He sought to confront O'Connell at the forecourts with the horsewhip. And again, you have echoes of O'Connell's threatened chastisement of the Attorney General Seán 2 years earlier. But the parties didn't meet until the 1st of February 1815, where they met at Bishop's Court in Kildare. The barrister Charles Phillips was one of the people who went with O'Connell to the ground. And Phillips records how O'Connell told him that this was a political affair and how they had underestimated him. O'Connell knew that because of his public presence, this day would come, and he told Phillips that he had trained himself to be one of the best shots in Ireland at a mark. Both men shot once. De Stair's ball missed, O'Connell's struck, and de Stair died from his wounds. O'Connell was ravaged by guilt over the killing, but the experience didn't temper the recklessness of his political language. 6 months later, in a speech, he imputed cowardice to Robert Peel, the then Chief Secretary of Ireland. Peel didn't let the insult pass, and instead O'Connell was challenged. There was a degree of publicity about the challenge which led O'Connell's wife, fearful of losing her husband, to go to the sheriff and to report the duel. O'Connell was arrested, placed under a bond, and he couldn't fight. But Peel wasn't going to let the matter lie there. Peel said, "I'll fight you in Ostend, outside of the jurisdiction of Britain and Ireland." And O'Connell felt compelled and did travel and made it as far as London. But O'Connell's wife wasn't the only one who knew that there was a planned duel, and he was arrested in London. When arrested, he was told that if he fought the duel, he would be tried. And the same applied to Robert Peel. He would be tried, and if convicted, that the likely sentence would be one of execution. He was offered the opportunity to enter a reconnaissance, and he did. That was O'Connell's last act of his dueling career. He submitted to the law, and he allowed the law to govern his conduct of affairs of honour. And that same attitude continued throughout his political career. When it came to duels, O'Connell refused all further challenges. I think we're fortunate indeed that when it came to O'Connell's struggle, he realised that he could arm himself not with shot and ball, but with reason, law and persuasion before he issued his challenge and took his ground against oppression. For having taken his ground, He stood it and he delivered. There's no doubt but that O'Connell deserves his place on Nemo's wall.
Some of the more astute of you may have noticed that there are 5 speakers indicated, but only 4 on the panel at the moment. And the 5th speaker was to be Paul Gallagher, Senior Counsel, and who was busy in court at the moment, but was due to arrive. This didn't worry me because although I'm now nearly 17 years a judge, before that, a small but significant part of my career involved trying to keep courtrooms busy awaiting the arrival of Paul Gallagher. But unfortunately, Patrick has just passed me a message at 3:46 saying that Paul is really sorry. He's still on his feet with a witness. Please convey his apologies to everyone. Entirely outside my control, which I take it to mean that it's the fault of some other barrister or some other judge, and that he'll be ransacking Nessa Cahill's paper for appropriate terms of abuse. But it is a real pity that we won't have the benefit of Paul's extensive knowledge of Daniel O'Connell's career. But that means that our final speaker tonight or this afternoon is Dr. Niamh Howlin, who's an associate professor at UCD Sutherland School of Law. She's the current vice president of the Irish Legal History Society, and she's a very distinguished legal historian and recently won a prize for outstanding contribution to legal scholarship for, I think, both her recently published books, one on the history of barristers in Ireland and the other, her book on essays on, or her edited essays on 100 years of the Irish courts, which were the a number of papers which were delivered at a conference last year in Dublin Castle to commemorate or to celebrate the centenary of the Courts of Justice Act 1924, which established the court system in Ireland. So it's a remarkable thing to have one book published, but a really remarkable thing to have 2 books published and to be recognised for her outstanding scholarship. And I'll ask Niamh now to speak to us.
Thank you very much for that very generous introduction, and thanks very much to Patrick for the invitation to speak at the conference today. Daniel O'Connell was a great believer in trial by jury, both as a matter of principle and as a matter of practice. So he really appreciated the role of the jury in its position between the individual and the state. And he also greatly enjoyed performing in front of juries. And we've had many anecdotes of some very well-calculated, dramatic performances by O'Connell. And Seán has also told us a little bit about O'Connell's criticisms of the composition of the jury in that McGee case. So as well as considering O'Connell's views on juries and his attempts to reform the jury system, I also want to talk about the case where O'Connell himself, I suppose, was most deeply involved in the intricacies of the Irish jury system. And this, of course, was his own trial for conspiracy in 1844. I'll start maybe by giving a little bit of context about how juries worked in the 19th century. So in the early 1800s, Catholic emancipation movement under O'Connell was still agitating for greater Catholic representation on juries. Even after 1829, Catholic representation on juries continued to be pretty minimal. In 1825, Robert Peel, the great reformer, had enacted a major piece of jury legislation, which unfortunately only extended to England and Wales, and it didn't encompass Ireland. Now, this had introduced a range of different reforms, and it really modernised the jury system at that time. For various reasons, it couldn't be extended to Ireland, and there followed then a decade of lobbying and attempts to introduce legislation for the Irish jury system. And I've listed on the slide here some of the unsuccessful bills that were presented in Westminster, including one by O'Connell himself in early 1833, which did not pass. Eventually, the issue gained so much momentum, and eventually one bill did make it through, and this was a bill by Louis Perrin, one of O'Connell's contemporaries. And this was enacted as the Juries Ireland Act 1833. Among other things, the Act changed the qualifications for people who were entitled to sit on a jury. And this greatly increased the representation of Catholics on juries in criminal cases and in civil cases. And it was generally hailed as quite a positive development for criminal justice and civil justice in Ireland. But it was problematic in a few different ways, not least of which was the level of discretion allowed to the local officials whose job it was to compile lists of jurors and lists of people to try individual cases. For any criminal trial, the local officials needed to know who in the district qualified to sit on a jury. And there was no easy way to figure this out. There was no centralisation of this information. So there was patchy and inaccurate local information, and this was often coupled with, I would say, lazy and corrupt officials, which meant that the jury lists, the lists of people who should sit on a jury, were usually incomplete and inaccurate. So every year, a date was set where the lists would be revised. And this would be something that was done in open court over a couple of days, and to which, in theory, anybody could turn up and say their piece. So members of the public could sit there along with local officials, justices of the peace, and make representations about who should or who shouldn't be on the list. And this is just an example of a public notice from a slightly later time period in County Roscommon. These would have been pasted all around the district, letting people know that these revision sessions were taking place. So it was all done in a very public way. So this was all very well in theory, but those revision sessions were usually quite chaotic and quite ineffective. For example, you couldn't strike any name off a list unless you'd given notice that you were going to do so. But the legislation didn't explain who was to give notice and how that was to be done and who they were to give notice to. So there were lots of little anomalies like that that made these sessions a bit chaotic. So attempts to revise the jury lists were often quite frustrated. The sessions themselves often were embroiled in allegations of bias and corruption as different vested interests sought to exercise control over who would sit on a jury. Whenever those local lists were finalised at parish level, they were supposed to be available for inspection for a few weeks, that again, any member of the public or any interested party could go along and see what the revised lists looked like. And then all of the parish lists for each district would be collated into one master list or jury book for the county. And it was from that book that the sheriff in a particular case would draw the names of people to be called as members of a jury for a particular trial. Generally, the sheriff would summon a few dozen men in the expectation that there would be no-shows and there would be people with excuses, and that eventually you would end up with 12 people for each case. Now, the background to O'Connell's case, O'Connell's trial, I think is fairly well known by many people here. He had called his monster meeting in Clontarf in 1843, and this he cancelled at short notice once it was prescribed by the authorities. Even though the meeting had been cancelled, nevertheless, O'Connell and a number of his colleagues were arrested, and they were charged with seditious conspiracy. And they were to be tried at bar by a special jury. A special jury was a jury who mainly comprised, excuse me, my slides are flying off ahead of me. A special jury was essentially a jury comprising of people of a higher social standing than people who sat on regular juries. So the legislation, which I've summarised on the right-hand side, so nobody has to read all of that, set out what you had to have in order to sit on a jury. So for a normal jury, you had to have either a £10 freehold property, or £15 of leasehold, or £100 of personal property. But if you were to sit on one of these special juries, you also had to fall into one of these other categories. So you could be a wholesale merchant, You could be a banker, the son of a peer, a local sheriff, a local magistrate, a baronet, and so on. And the idea behind these special juries was that in some cases, it was considered desirable to have a jury of a higher social status. And there were primarily two reasons for this at this point in time. First, it was considered that these people with a higher social status would be more intelligent. And secondly, that they would be more likely to be pro-government. And that's very relevant when we talk about O'Connell's case. Now, special juries weren't usually used in criminal cases at this time. Usually these were used in commercial cases where there was a lot of technical evidence being presented. But they could be impanelled for what was called a trial at bar, and that's the kind of trial that O'Connell was to have. So a trial at bar, I'm just going to get the right picture, was a trial in the superior courts that was in front of a panel of judges and a jury. So quite different to anything that we currently have, where we either have a judge and a jury, or a panel of judges. So this illustration of the trial of O'Connell shows that there were 4 judges up on the bench. And you can also see the members of the jury in the background. That's their hats hanging on the wall behind them. So these were comparatively rare, these types of trials, and they were only kept for the kinds of cases that were considered to be of significant public importance, colloquially called state trials. Now, O'Connell and his team, facing this mode of trial and knowing as much as they did about the way that jury lists were compiled and the likely composition of the jury, wanted to have the trial postponed until the spring of 1844. And the reason they wanted to do this was because that would be after the revision of the jury lists, because they knew that there was going to be a high proportion of Protestants on the jury lists, very few Catholics, and they wanted a chance to try and alter that. Excuse me. So this picture here shows the revision sessions at the Recorder's Court in 1843. So the recorder was a man called Frederick Shaw. He sat in November to revise the lists, and members of O'Connell and his colleagues' legal team attended every day and made an awful lot of objections and interjections as the proceedings went on. And this wasn't something that was completed in a day. There were 2 weeks of this, of people arguing over whose name should or shouldn't be on the jury list. About 1/5 of the names that were on the list shouldn't have been there. For one reason or another, either the person didn't hold the right amount of property or the person was in fact deceased. Of the 388 men who were listed, 53 of those were Catholic. 30 of those Catholics were going to be exempted for one reason or another. So it really left only 23 potential Catholic jurors in the whole of Dublin. One of O'Connell's lawyers claimed that there were at least 300 additional Catholics in Dublin who were qualified to sit on these kinds of juries and who should have been on the list. And further investigation showed there were probably about 400 people in total who'd been left off these lists. So it took 2 weeks for the revision to be completed. Then it took a further month before the revised lists were sent on to the Dublin sheriff. In the meantime, unsurprisingly, things went missing. So some of the revised lists went astray. One was later found under somebody's desk in an inner office. So it was very, very chaotic. That list that had gone astray had 15 names on it from a particular parish, and 13 of those names had been the names of Catholics. So you can see how all of these incidents were, I suppose, coming together to create a certain outcome. Now, because O'Connell and the others were to be tried by this special type of jury instead of a common jury, there was a particular procedure for selecting the 12 men who would sit on the jury. So what would happen would be that from the hundreds of names on the list, 48 would be drawn at random from a box. So they were picked at random. Each side would then have the opportunity to object to 12 of those names, thus bringing the list down to 24. And those 24 men would be summoned to court. And that would allow for a few no-shows and a few challenges. But the first 12 of those men who turned up to court would be sworn in for the jury. So this all took place for O'Connell's trial in early January, at the office of the Clerk of the Crown. Now, when O'Connell and his team turned up that day to scrutinise the jury list, it became very obvious that dozens of names of men who should have been on the list had been omitted, including some very prominent and wealthy Catholics from around Dublin. And this was despite all the efforts they'd made back in November at their revision sessions. One of the lawyers said it was either an unpardonable mistake or it was underhand collusion. So despite all of this, the 48 names were drawn. O'Connell and his legal team did object to quite a number of things that happened in that procedure. But again, the names were reduced, and they reduced them again to 24. And when the Crown came to strike their 12 from the list of 48, they struck out all of the Catholic names who had remained on the panel. So it was patently obvious at this stage that the trial of O'Connell, the great emancipator, was going to be before a jury entirely composed of Protestants. And here we have the names of the jurors from the trial of O'Connell. And it is possible in the trial reports to find out more about the individuals. So on that first day of trial, the 24 men who had been called turned up. Some of them didn't turn up, and they were threatened with fines of £50. And then after those fines were threatened a few times, more people turned up. But there was definitely a reluctance among those who were called. A lot of people didn't want to be involved in this trial. They didn't want to be associated with it. And a lot of them just didn't want the hassle because it was predicted to be quite a lengthy trial. So there was a bit of wrangling. And as different jurors were called forward, they tried to make excuses as to why they shouldn't have to sit on the jury. And there was a lot of laughter in court. People came up with all sorts of different excuses. There was one man, for example, who said that he had very important business to attend to. And he produced a certificate from the Lord Mayor of Dublin, which said this man has very important business to attend to. And the court said they weren't going to accept that. There was no legal standing for that. So then the man said, "Oh, but I'm also unwell." And from the crowd came this man's apothecary, who tried to give sort of medical evidence that this man was of a nervous disposition and that he suffered with his nerves, and he would be very nervous if he had to do the trial. So there was an awful lot of that. And it took half a day to swear in the members of the jury. Now, before the jurors came to swear their oath, once they'd figured out the 12, O'Connell's team submitted what was called a challenge to the array. So simply put, there were two ways that you could challenge a jury: a challenge to the poll or a challenge to the array. So a challenge to the polls was where you objected to a specific individual juror. And a challenge to the array was where you were challenging the way that the jury list had been compiled. So you're challenging the validity of the whole jury. So here he was challenging the array of the jury on the ground that the jury hadn't been compiled in accordance with the 1833 legislation. The challenge was disallowed. Unfortunately, the trial had to proceed. This trial was predicted to last for several weeks, and the Attorney General made the suggestion that maybe the members of the jury should be accommodated in a hotel for the duration of the trial. Now, the jury were not having any of this, and they said they all had, again, very important business affairs to attend to, and they couldn't be kept away in a hotel together for a couple of weeks. So the judge agreed that they could go home every evening to attend to their very important business affairs. It was a long trial. There were 2 weeks or so of evidence and arguments, and then the jury went off to consider their verdict on a Saturday evening, about 5:30. And there was a lot of toing and froing as they tried to reach a unanimous verdict. And eventually midnight rolled around. And the judge brought them back in, Judge Crampton, and said, the court, it's midnight now, so it's a Sunday, and the court cannot receive a verdict on a Sunday. So we're going to have to postpone all of this until Monday morning. But because the jury deliberations had already begun, the jury were not allowed to separate. So they had to stay together, not in a hotel, but just in a room in the court building for the rest of the weekend. So they all had to stay together while everyone else went home. The one exception, they were only allowed leave to go to church on Sunday, which they had to do all together under the supervision of the sheriff. So unsurprisingly, by Monday morning, the jury had managed to reach a unanimous verdict. And of course, they found that O'Connell was guilty of conspiracy. So he was sentenced to a year's imprisonment and a fine of £2,000. Now, the matter didn't rest there because O'Connell sought to have the verdict set aside. And he came back in, or his lawyers came back into the Court of Queen's Bench about 2 months later with this application for what was called a venire de novo, so an application to have a new trial. He wanted the verdict set aside on the ground that the jury lists had been fraudulently made out for the purpose of prejudicing him in his defence. Now, Justice Perrin was somewhat sympathetic, and he did think that there had been errors with the way the lists had been made and that the challenge to the array of the jury should have been allowed. But he was in the minority. And Justice Crampton, in particular, was very critical of O'Connell's application. He said that O'Connell, first of all, had failed to establish that there was any fraud and that he'd failed to establish any prejudice against him. Now, the judge did accept that there probably was a lot of negligence in the making out of the jury lists, but there was no basis for an allegation of fraud. So the verdict stood at that point. Now, later on a writ of error to the House of Lords, the judgment was reversed, not on grounds relating to the jury, but because there were errors in the indictment and the way that the indictment had been written out. So famously, O'Connell didn't serve his full year imprisonment in Richmond. He just served 3 months, and I think it's been well documented that that was done in relative comfort at that time. So to conclude, at a time when the composition of a jury was seen as affecting the outcome of a case, it was fairly typical to see attempts being made to exercise control over who ultimately would be the 12 men who would sit in the jury box. There were lots of opportunities, both legal and extra-legal, one might say, to do this, from the making up of the jury lists to the revision of the lists to the striking of the jury panel or issuing challenges. Were the various issues rising from the jury in this case atypical? I would say not really. So there was nothing that happened with the jury in the trial of O'Connell that didn't happen in another case around this period. So everything that happened here had a precedent. But it was unusual to see so many of these issues come together in one trial, I would say. So given the profile of the accused and the wider context of the case, it's probably unsurprising that there were no Catholics on the jury which tried Daniel O'Connell. Thank you.